This is Senate Bill 146.
Yes, sir, Mr. Chairman.
Yeah, I think it. All right.
Yes, sir, Mr. Chairman. Good morning.
Before we start with JP's bill, can we pass out the co-author sheet on 138?
Mr. Chairman, I get a copy of my own bill. I didn't bring one with me. Apologize.
Do you want the one with my notes on it?
I don't know if I'd understand your lengthy notes. You've probably scribbled all over the bill. So I prefer a clean version. You might distract me.
All right.
Might have me doubting myself, Mr. Chairman.
All right. So this is Senate Bill 146, members.
Thank you, ladies and gentlemen. The bill's pretty straightforward. Many of you are familiar with what a material witness warrant is. Basically, if there is a witness to a crime and the district attorney believes that witness may not make themselves available for trial, they can preemptively incarcerate them to secure their testimony for trial. I'm going to focus my attention on the bill itself and not the material witness practice, because I'm not here to attack the practice of using material witnesses. Specifically, what this bill seeks to do in the case of domestic violence or sexual assault, it simply says that you cannot use a material witness warrant to secure a victim of domestic violence or sexual assault, secure them and incarcerate them to make them testify. For those of you who do not know, obviously the process of prosecuting sexual assault and domestic violence cases is very difficult, and I acknowledge that, and I understand for DAs it's very difficult. But in the same token, there is a lot of trauma surrounding an incident, sexual assault and domestic violence, and simply put, you re-traumatize a victim by incarcerating them to make them testify, and the probative value of jailing a victim to elicit their testimony is just offensive on its face. And like I said, I have been approached by, I cannot tell you how many groups to expand this bill to deal with the material warrants practice, and I have told all of them no, because I will be the first to say, depending on the circumstances, it might be appropriate. But when you're talking about these two affected groups and how it affects them in this process, it can be as traumatic being jailed while they try to bring a case to your accuser. And I'll tell you this very simply, because it has happened. There have been instances where the victim gets more jail time waiting for a trial than the person ultimately gets who's convicted. So, all right. That's what I have.
Well, thank you. Let's see here. I'm going to read the green cards and see who we're going up, and I'm going to welcome a New Orleans City Council member to the chamber. We have Julie Harris in favor, would like to speak. Kelly Garrett in favor, not wishing to speak. Susan Nelson in favor, not wishing to speak. Will Harrell will speak if you want to talk to him, in favor. Taylor Robinson in favor, will speak if requested. Angela Adrians in favor. Ann Steyer, Marshall Burns, Jennifer Harding, Ryan Haney, John Burkhart. Those that are in favor and wish to speak is Helen Moreno at the table. Morgan Lamadre. Morgan, if you're wishing to speak, come forward. And Darren Broder, if you would.
I'll yield the table to him so you can get up here.
Darren. And we're going to go right to left, and let's try not to be repetitive. My right.
You got it. Well, good afternoon, or I guess morning. We're still in the morning. It's really actually very nice to be back up here with you all. I miss you all. I do. So be nice today. I'm here to support Senator Morrell's bill Senate Bill 146. As you all know, during my time in the legislature, I really worked to help victims of domestic violence and sexual assault. And you all have been very supportive with those pieces of legislation. And you all really understand the complexities of domestic violence and sexual assault cases. And you recognize that the criminal code actually treats those cases differently than others because of their complexities. And also, in particular with domestic violence, because of the intimacy of those crimes and the relationship with the offenders. The offenders are often family members, a dating partner, or a spouse. And as you can imagine, and I know Senator Coloma, I know you were a victim of, a survivor, I should say, of domestic violence, that the trauma that goes along with domestic violence is severe, because that is a loved one who has treated you in this terrible way. So oftentimes, victims of domestic violence in particular, they do have this reluctance to testify against their offenders because there is that intimate relationship. And oftentimes, when these cases proceed, victims are really reticent to testify because they're getting threatened by the offender as well. And some of those threats include sometimes the children. You know, you're never going to get to see your children again, or even, you're right, Senator Curlone, even potential harm to the children. So really the best way to entice a victim to testify is to offer really necessary services that will make he or she feel supported and protected. And I would say that threatening to put her in jail or throwing her in jail is not going to make that victim feel that way. And in fact, I would say it's probably the most cruel way to try to entice testimony from someone who not only is an innocent victim, but a traumatized victim as well. This particular practice has really been looked at as now being archaic, wrong, and unwise, and it's actually being admonished by DAs all across the country. Most recently, I read an editorial by Houston's District Attorney, Kim Ogg, who wrote in a USA Today editorial that, quote, subjecting crime victims to jail when they have committed no crime is an abuse of prosecutorial discretion and an affront to the prosecutor's duty to pursue the interests of justice. It undermines the integrity of our justice system, which at its core relies upon public trust between law enforcement and the people. She goes on to say that jailing of victims to produce testimony has also proven to lead to false testimony and wrongful convictions. I mean, imagine if you are thrown in jail as an innocent victim and the only way you can get out is to testify against someone. Well, you may be willing to say whatever just so you can get out of jail. I also want to mention that there are also VAWA implications, the Violence Against Women Act in the federal government. The recent bill on reauthorization actually calls for states to do away with these policies. And to be in compliance with VAWA, we would actually have to work to do away with these policies. So this bill would actually work to put us in line. I want to mention that the state of Louisiana receives a little bit over $5 million, or roughly around $5 million towards victim services for LCLE. Some of that money goes to district attorneys' offices. So that money is critical. We have very little money, as you know, from your local providers when it comes to victim services. So if we were going to eliminate this federal funding, that would be a significant problem. So despite what some of you all may have been told, that this has to be a necessary option of jailing victims, I can tell you that across the country, best practices are saying that absolutely this is an archaic practice. So I just very respectfully ask you to vote to do away with this practice and vote on behalf of victims. And I would also just say that to echo with what Senator Morrell said, is that this is not against material witnesses, material witness warrants, I should say. This is just about that option to jail should be done away with. So material witness warrants, those can proceed. You can say, the victim's got to come to court. You've got to go before the judge. All of those different things. Just take away that option to put him in jail. And I'm more than happy to look at all different types of options, just as long as one of those options is no longer jail. Thank you.
All right, thank you. We'll hear from the whole panel. Okay. Yes, sir. Introduce yourself and tell us what you'd like to.
My name is Darren Browder. I represent Court Watch NOLA. We received this data through court watching in New Orleans. Of that year, 2016, there were at least 13 material witness warrants that were issued. Of those 13 warrants, there was 7 arrested individuals, 2 females, 5 males. As Senator Morrell talked about earlier, that some of them spent more time in jail than their offenders did. The first female victim, she spent 8 days in jail. She's the victim. It was a second-degree rape and a second-degree battery. That was the charges against her offender. The female victim number 2, she spent 6 days in jail, and the charges against her offender were aggravated assault with a firearm. The male victim, male victim number one, spent 18 days in jail. The charges against the offender were attempted second-degree murder, possession of a firearm by a felon. Male victim number 2 spent 179 days in jail. The charges against that offender was attempted second-degree murder, armed robbery with a firearm. Male victim number 3 he spent 1 day in jail, and the charges against the offender were aggravated burglary, aggravated second-degree murder, aggravated battery. And male victim number 4 spent 1 day in jail, and then the charges against that offender was attempted second-degree murder, manslaughter, and second-degree murder. These are pretty serious charges, and I could see where someone would be reluctant to testify against someone who was trying to kill him. But this is the data that Court Watch NOLA received through watching court and then civic engagement of the court watchers. And I thank you if you have any questions.
Thank you. We're going to hear from Ms. Lamadre, and then we'll pose questions. So you're welcome to stay there if you wish, or have a seat. Go ahead, Ms. Lamadre.
Hi,
Introduce yourself.
Yes, I'm Morgan Lamondre, and I work for STAR. It's Sexual Trauma Awareness and Response. And that was a lot of information that I know came from New Orleans. So before I get into some issues, I do want to say in East Baton Rouge Parish, where I know 4 of you are senators, we should be very proud of our parish. Hiller Moore, our district attorney, this is not a practice that he uses. He also ensures that victims receive lots of services by supporting STAR, supporting Irish domestic violence programs. So our parish should be a model for this. We have ADAs that do everything they can to work with victims so that way they feel safe to be able to testify. And in order to make victims feel safe, they are more inclined to come forward to participate in the criminal justice system. So that's something we actually can be very proud of in East Baton Rouge Parish. And just a few other things to kind of talk about that. The problem that we're seeing in other areas is that a big thing is there's no right to counsel for a victim who does get jailed because they're not considered charged with a crime. So if maybe there was a right to counsel, there's also no provision that prohibits them from being jailed in the same jail as the perpetrator, which is so unsafe if we're really talking about safety. And we don't want there to be any unintended consequences. We want prosecutors to be able to take care of, protect protected citizens from any offenders, but we also don't want to traumatize survivors in that process. I think no matter what, in the end, if a victim is forced to testify, and really it's about the jailing of it. There's many reasons why victims may not be able to come forward. Our Crime Victims Bill of Rights does not guarantee any job protection for victims who are forced to not go to work. So, there's other ways too that ultimately we all want the same thing. We want everyone to be safe. We want victims to be able to get some form of justice. Justice isn't always jail for survivors, but we want them to go through that process without being traumatized. Thank you.
Thank you, Ms. Lamadre. If the committee would be agreeable to this, I'd like the opposition to be able to speak, and then we'll ask the questions that we have, if that works. Okay. Thank you. Sonia.
You have one more person up to speak. Be put in a card.
All right.
Thank you. My name is Julie Schwamp-Harris from New Orleans, Louisiana, and I will not repeat the testimony of others that spoke before me. I'm very much in support of this bill and did write you yesterday evening just to make sure that you know that the coalition that I work with that works on a far range of issues relating to women, including health and economic security, supports this bill. Obviously, the state has had a problem with protecting women and with violence against women. And we used to be the most dangerous state for a woman to be a victim of domestic violence. We are now the second most. I guess that's an improvement, but we still have a problem. And government cannot always protect women from their abusers. We also know that in domestic violence situations, the most dangerous time for a woman, for her family, because often it is the family that is the target of the violence, for her children, her parents, is the time when she makes a decision to leave or makes a decision to call the police and try to involve to get some safety, and yet may make a self-preservation decision not to testify. I want to make sure that the link between the violence against women and the economic situation that we face in this state is recognized. The domestic violence organizations talk about the fact that one of the risk factors of violence against women is the economic situation that she is in. It makes it harder for victims to leave abusers. It also aggravates just the tensions within families that may even trigger reactions, mental health issues, and abuse. And so we have to pay attention to the economic situation that may drive a victim to, for self-preservation reasons, stay within that family. And we have to work on those structures by providing fairer pay, by providing paid leave that is sensitive to domestic violence situations, by providing living wages in order to prevent the victimization of women. I hope you will support this bill. Thank you.
Thank you. I'm going to do a slightly unusual thing. We're going to take a break from your bill. We're going to call up Senate Bill 138, which is Senator Gaddy. The amendment, if we can pass out Senate Committee Amendment 638. What the amendment does is what we discussed earlier about limiting it to the traffic side, and then the bill, this section would be known as the Katie Grantham's Law. I know that we like Katie Bug a little bit better, and but the amendment's drawn this way. We can fix that on the floor. So the committee as a whole, I believe, offers the amendment. Is there any objection to the amendment? No objection to the amendment. Now the bill is in posture for a final vote. Senator Colon moves as amended that we report Senate Bill Katie Bug Law favorably. Any objection? Seeing no objection, Senate Bill 138 as amended will be reported favorably. Thank you.
Thank you, Your Honor. Your Honor,
Yep.
I may be a little early on that. Mr. Chairman, thank you for your time today on this committee. Thank you for letting us do this today. A lot of folks have driven 4 hours or more to be here today, and I would just like to acknowledge them if they could stand and thank them for their presence.
So if you would stand, this is. While we're not the House, this is the Senate. This is still your house, and we appreciate having you here. You're not visitors. You're at home. So thank you for coming.
And we've also have several green cards of the folks that are here today. I don't believe it'd be necessary to read them into the record, but we appreciate you.
Yeah, the bill's been reported favorably
Thank
as
you.
amended. So
Thank
when
you.
you're winning,
Yes, sir.
yes. There we go. Thank you for coming. All right. Now we'll return to our previous programming. Senate Bill 146. We've heard from we're going to have questions at the end. So now I'm going to call those in opposition. Sonia Porter from the 19th JDC, Kathleen Barrios from the 19th JDC District Attorney's Office, and Charles Ballet. If you would come forward, work it out amongst yourselves who should go first. I'm going to suggest Miss Carter.
Cardia Porter.
Cardia Porta.
And Senator Clayton, I think.
If you're right to where I could read it. Thank you. All right. So, members, we're going to have a demonstration or an opportunity to hear something at some point, but we're going to go left to my right, your left, across the...
first.
Yep. And then introduce yourself and tell us what we need to know.
Good morning. My name is Sonia Cardia Porter. I work here in the 19th Judicial District. I'm a prosecutor and I handle only sex crimes. I work for the District Attorney's Office every day, all day, every week. I handle sex offenses. I'm here to speak against this bill for material witness warrants as it relates to sex offenses and domestic violence victims based on my experience as a prosecutor. I want to let you know that I've been a prosecutor for over 18 years. I was a prosecutor in New York City, in Queens County. Most of my practice was focused on domestic violence. I then relocated back home, Baton Rouge, Louisiana. I've been a prosecutor since 2004. I've handled every type of case, whether it be a forgery, murder, theft, but I have the privilege of running the sex crimes division of our office here. So I am very familiar with the trauma that victims experience, and I work very much to give them a voice in our criminal justice system. I feel that this bill as written and as it's created, although intended to help victims, that it's actually helping the offender. It is so easy to stand up and say, don't jail victims. And I will say that in my 18 years as a prosecutor, I have never requested a material witness warrant for a victim. But that's not to say as a prosecutor, I believe that we should not have that option. You all create these laws that identify crimes. Our burden is to prove these people are guilty of these crimes. Sometimes the only evidence that we have is that victim who called to law enforcement for assistance for a violation of law. That case comes before us, and we have chosen to stand up for these victims and give them a voice. As the state of Louisiana, we institute prosecution against these perpetrators for violating the laws that you create. None of these laws that you create say if the victim does not want to proceed, it's not worth proceeding. Every day we have hundreds of cases, and we try very much to empower these victims and give them a voice. We care very much. And I do believe that going against this bill as written is assisting in muffling the voice and empowering the defendant. I want to talk to you a little bit about some of the reasons why. It is not easy to stand up against your offender. I know and I get it that they experience trauma. And that is why having a victim advocate, having prosecutors educated, is very important. It takes time. The victims that we finally get to trial, I will tell you, it has been a process. And sometimes they don't initially want to talk to you, and it is very much a process, and we rely heavily on our community partners to work with us, because you know what, we have so many cases, we don't have the time to give to these victims, and because of the trauma that they experience. So we work very closely with community partners, but we also have a responsibility to the community to seek justice. How many times do you read in the paper that there's another sex offender that commits another sex offense, a domestic violence perpetrator who kills the victim or who does it again, in and out of jail, in and out of jail? Those cases are in and out of jail probably because we did not request a material witness warrant and compel that victim to testify against the perpetrator. We have empowered that victim and given them some sort of justice and some sort of voice by letting them trust the system. I do believe that, I know that it's difficult if I see a defendant that I have not requested a material witness warrant and a victim who did not want to come in and testify against him if he does it again, and we can't prevent that. But we do have a responsibility to the community, too, to protect them, to protect future victims. It is often a measure of last resort for prosecutors. as it's currently written, the way that the legislation says is that it's absolutely prohibited against victims of sex offenses as well as domestic violence victims. These are some of the victims that we need to protect the most. These are some of the victims whose voice has been muffled. It was scary just to even call the police. And by creating this legislation, what I really do believe is going to happen is it's going to have a chilling effect, where the perpetrator is going to encourage them not to follow through with the criminal process. No victim, no case. Don't let them find you, because if you don't come to court, nothing will happen. And I want to just talk in particular with sex offenses. There are different types of sex offenses. We have trafficking cases, then we have rapes, we have sexual batteries, then we have sex offenses upon juveniles. And every victim that I have the privilege of working with, I want to work with them to find that voice. But I do believe that you have to look at every single case and the situation of every single case. And creating a blanket policy preventing this is really discouraging victims to come forward, because of what's going to happen. The defendant's going to say, nothing's going to happen to me if you don't come to court. And most of these victims may lie, but they're not going to go to jail. And again, I want to say we do not want to put these victims in jail. We do not. But we have to be able to use tools, the power of subpoena, the power of court orders to get them there. I will say most of them don't want to voluntarily walk into that courtroom sometimes because it's scary. And that's what I mean by it's a process. I am not about jailing a victim. I am about empowering them. But I do believe that this bill is very offender-focused and not as written, and it's not empowering the victim. Again, I've emphasized that we work very much with our community partners, and I have never requested to jail a victim, but I do believe that it should be a tool in some instances. I want to talk about some particular cases that I see that this bill would affect in our ability to prosecute. Again, you all create these elements that we have to prove beyond a reasonable doubt. Every defendant is innocent until proven guilty. In human trafficking cases, most of the trafficking cases that we see are not a child who's kidnapped in Walmart and then taken and subjected to do certain things. A lot of these trafficking cases are women who are groomed by perpetrators. They are women who have often been runaway, homeless, and for some reason or not, they identify with the perpetrator who also becomes their abuser. So it's an intertwining of a domestic violence, and they identify with him. Most of the traffickers are hims. I will say that in a lot of these trafficking cases, these women, without him, they have nothing. They don't have protection, they don't have money, and it's very difficult. So it's a process. I don't think that they're going to want to cooperate. And in many cases, we can't pursue because they don't want to cooperate.
So
Again, I have never requested a material witness warrant, but I think that is something, as a prosecutor, we need to be able to have the power to do.
Sonia, half this committee or 2/3 has to be in another committee at 11. So I'm going to ask that you yield and that we hear from Kathleen.
Yes.
And we have questions that'll come to both y'all, and so we'll have a chance to go into that further.
So, Senator Claytor, I just want to echo
Introduce yourself, please.
Kathleen Barrios. I am an assistant district attorney in the 19th Judicial District, and I also have been a prosecutor for more than 10 years, and I personally have never sought a material witness warrant for a victim. We did some data collection at our office, and we certainly do not support the idea that we want to put any victim in jail. We do not want to compel the testimony of any victim that way. And I'm hopeful that maybe we can work with the community partners, with Councilmember Moreno, to reach a compromise here. But we found that between the last 3 years, 11 material witness warrants were sought in our office. Of those applications, 2 were for victims, and 1 was for a human trafficking case where there was a man who was grooming individuals for human trafficking, as well as for a domestic abuse battery third offense. Now, neither of those warrants were executed, meaning the victims were not arrested. They were applied for, and when that information became known, they voluntarily came to court. Of the 11 material witness warrants that were executed, only 5 were executed. During the same time period, we filed approximately 45,611 formally charged cases. This represents 0.0002% of all of our cases. Ms. Cardia Porter has been talking a lot about how this relates to sexual assault cases, and I do share her concerns that this could affect domestic violence cases. And we did have a case where one of our prosecutors felt the need to apply for a material witness warrant, and thankfully it was not executed. The defendant ended up pleading guilty. But I fear that, as written, this only restricts the power of the district attorney. So the subsection B, as proposed, the defense could still apply for a material witness warrant for a victim and imprison them. I think that this could further enable a perpetrator to secret a victim from us, because that's what a material witness warrant is. It's someone that you cannot effectuate service on. That there would be no case, there's nothing they could do to you. I do believe as a prosecutor this should be a tool of last resort. That this should only be something in all cases that you apply for after exhausting all other efforts to locate a particular witness. I think that this could create consequences of abusers knowing that we don't have a way to compel their testimony. I think that perhaps a compromise that could be reached is perhaps what kind of showing needs to be made in order to secure a warrant such as this. I also want to just address some of the data that was just brought before you, in that from what I recall from Court Watch NOLA, only one of the cases described would fall under this statute, because only one of them was a second-degree rape. Armed robbery, attempted murder is not covered by this. So I don't know that those are relevant examples to include, because this is so rarely used. I have, with the permission of the chairman, we had asked to be able to play one jail call from a domestic violence case that we had in our jurisdiction. And I do want to warn everyone in the audience that there are profanities and racial slurs in this phone call made by the perpetrator of this offense, if the senator will permit us at this time.
I think it's material.
To keep it down, because Jim Ho said something I didn't like, and I said, man, fuck you. My mom and them kept looking at me like, my mom and my uncle kept looking at me like, be cool, bro, because you know if you do something to that dude in the courtroom, you're going to have another charge on you. So he was sitting in front of me with his leg crossed all cocky, but he went and talked to the DA before he talked to me. I ain't like that. So I said, man, how the fuck you going to come talk to the DA before you talk to me? And I know she ain't fixing to do nothing for me.
Okay, go get some more too.
So I'm on another level with him, but at the same time, man, she said it back because she think you her witness, dog. That's what I'm telling you straight up. Cause she hollered, but she ain't got all the evidence yet. And
so that's what I'm saying. So what do you want me to do? You want me to come to court or not come to court? Because like when you talked to Travis and you was like, come to court, and I was supposed to.
No, I don't want you to come. Listen.
Right.
See, before I go to trial, I was trying to get this shit through. I told you be doing too much with him on the phone, because I think I'll be having to explain it to you twice. I don't want you to show up to trial. They got to throw it out if you don't show up at trial. You know what I'm saying? But at the same time, before the trial, like at this hearing, I was trying to get you to come to court. If I see Jim O told me something, and I had to make sure that it was already legitimate. So I told everything with Jim O telling me, I'm running it through another lawyer. I'm running it through your lawyer. But he can't be on this phone with me because that's a conflict of interest if you have to show up in the courtroom.
All right.
Because he can't voice his opinion to me and represent you at the same time.
So, just in closing, I don't know how understandable that is.
Hey, hold on.
I don't know
I don't know another way to present it other than have a lot of bleeps. I get that. We gave a warning beforehand. some of the committee members are shocked that we would play it, not shocked by the language. We're not approving of the language, but I understand what the purpose is. But go ahead and tell me in 30 seconds or less what we learned from that tape.
I don't know if y'all can hear that there are other victims in the background there. They're the children that are in this household. And what is happening here, and this is so frequent, that perpetrators are instructing victims not to come to court, to not cooperate.
All right. Thank you. All right, Charles.
Thank you,
Introduce yourself.
Thank you, sir. Mr. Chairman. Yeah, Charles Ballet. I'm District Attorney of Plaquemines Parish, 25th JDC. I'm also President of the Louisiana District Attorneys Association. This bill, as in any bill, we discuss at great lengths in our association, decide positions, and I can tell you it's unanimously opposed by all the DAs because it's a tool. This tool is very, very necessary for us to use on rare occasions. It's very seldom used, and Mr. Lauren Lampert, our Associate Executive Director, I think it's going to be next, tell you I think it's less than 0.002% of any cases, of all the cases, thousands of cases like this is ever used, and not just domestic violence or sex cases, but all cases, even the homicides, attempted homicides, etc. I want to tell you about a particular case that we had and ask you what would you do, I suppose, if you were the prosecutor in a particular situation.
Charles.
Yes, sir.
I'm going to cut it short and go to the questions in that we've got 15 minutes. We have two more bills. I think we've done a good job of summarizing it on both sides. Go ahead.
I'm sorry. Just if we have a particular case where somebody was raped, kidnapped, aggravated burglary, everything in Plaquemines Parish, come to find out this person had done the same thing in Texas, spent 16 years, and then when we dove deeper into it, he was released from Castro's prison in Cuba years ago for offenses there. How he winds up in our territory, I don't know. But what I want to say is that after the arrest was made and the victim made great statements, and she is the witness, she is the evidence like this, as people do in these situations, was very scared and took off, could not locate her. Our sheriff's office tries everything. We hear maybe Tennessee Sheriff's Office tries everything, can't do it. The only way we can do it, and this guy's trial is coming up in 30 days, the only way we could do it is to get the U.S. Marshal Service involved, which is one of the best agencies in America in finding witnesses. The only way they'll act is having a warrant. We've used them for getting people from Philippines, Puerto Rico, all over the place, and they have to have a warrant. So we have to have a warrant to find this witness, Miss Roby, like this, and so we could have her in court. This guy, as sure as I'm sitting here, if he had not been prosecuted successfully, 85 years in Angola now, he would be out raping and beating and traumatizing women again and again and again. So this is rarely ever used, but it's a tool that must be used. I just want to go on to say that I agree with the concept, or what Senator Morrell and Council Lady Miss Elena Morena is after. But I think the problem is much bigger than just rape cases, sex offense cases, and domestic violence cases. Homicide cases, attempted homicide cases, our victims are extremely traumatized. I think we need another approach to correct some of these other problems than this bill, how it's worded here.
All right. So I'm going to read the red cards. Our members have been patient holding their questions. We have some questions. Senator Colon also is going to have an amendment. So I'm going to run through the green cards again, then I'm going to run through the red cards, and then we'll go to the questions. If you just yield your seats, we'll see where the questions fall. So we heard from Ms. Harris. We heard from Ms. LaMadre. We heard from Darren. We heard from Helena in favor. I read the other green cards. If any of the members want to see them, they're the green cards. On the red cards, we heard from Ms. Barrios. We heard from Mr. Ballet. Also in opposition is Hiller Moore. In opposition, Lauren Lampert. In opposition, Pete Adams. Ms. Swain. Ms. Michael. Mr. Allman. Mr. Fortunato. Ms. Richard. And then Sonia Carter Porter also spoke to us. So question number one comes from Mr. Carter, Senator Carter.
So I've listened with great interest on both sides of the issue. And I think clearly we recognize that a person that is a material witness plays a significant role in the prosecution of a bad guy or a bad person. Where I have a bit of a disconnect is the adding insult to injury of taking a person who's a victim and exposing them to a criminal justice system behind bars when in fact they've been victimized. So now they're doubly victimized, and we already have a situation where these types of crimes are underreported because many times the victim is treated like a criminal, and so we don't report rapes or incidents of domestic violence. So my fear is this practice of arresting or detaining in a prison setting a material witness in cases of domestic violence and or rape will further exacerbate the issue of non-reporting. But I am also sympathetic to the issue, certainly as what DA Ballet has just suggested about this particular person that was captured and spent the rest of his life in prison because they were in fact captured and because this person was found in Virginia and testified. So I've got to believe that we're able to still get material witnesses to participate, even by subpoena, without putting them in jail. There has to be a safe place where that person, what happens in cases like protective witness protection plans, or something that does not take a person's rights or freedom away from them while allowing them to participate in the process to help the bad guy or bad person be prosecuted. So I would hope that we can find a way to do away with the practice, and I'm supportive of doing away with the practice, because I don't think women or men who are victims should be doubly punished because they happen to be a victim. Material witnesses are important, and we recognize that. But we've got to find a better way to do it. And I think perhaps between now and the floor, we can talk about some safe places, a safe home, or some place that person can go so they can participate. But the person that fled, in the case of the Virginia lady that fled and came back and prosecuted the rapist, she ran because she was afraid. And so if we encouraged people to come and participate and they would be made safe, but not locked up with criminals, not put in a place where they're put in further harm. Particularly the statistics that was demonstrated today that in some cases they spent more time in jail than the person that was accused of the crime. That's horrific. We cannot send a message to victims of rape and domestic violence that we're going to make it more difficult for you to come forward. You know, in 2019, we want people to come forward so we can prosecute the villains. So we should make it easier for people to come forward, not more difficult. So that's my commentary. I would hope that between now and the floor, the DAs and those that are in opposition will come to the table along with you, and I'm more than happy to participate as well, and find a way that we create a safe place, not in jail, not behind bars, where material witnesses can come to help prosecute the bad people.
Thank you, Senator Carter. And are you the same Carter that's a co-author on this bill? All right. Senator White. Senator White.
Thank you. I think we all sit here a long time, Senator, and listened, and it is truly a horrendous problem in our population. But from what I've heard, the testimony, as I listened to every word I could, is I don't know how many years, I don't recall, I didn't write it down, but there were 13 warrants issued in New Orleans. There were 7 arrests over a time of years. And there was one person, I think it was a man, done some substantial days. Nobody else had more than 1 day. And let me finish.
I'd say.
Of my DAs on the 19th and the 21st, they don't arrest them. So the whole North Shore doesn't use this practice unless it be some extreme, extraordinary case that they still want to have the tool. I didn't have any other testimony from anywhere else in the state where they're locking up victims of rape and domestic violence. And as you know and I know, and the people sitting on this panel knows, that someone that commits a sexual offense, especially rape, or aggravated rape, or is a domestic violence, or loves to beat their partner, whether it be male or female, they're going to do it again if you don't put them in jail. If you don't punish them, they're going to keep doing it. It's proven, especially with children. So I understand you have a problem in your parish. Or you had 7 people that were incarcerated at some time of the thousands of cases that were brought. So my question is, how big a problem is it?
Those 7 cases were from 1 year,
Okay.
not for all of time.
Okay.
That was
So
that
those
was-
7
that was
cases,
people from 1 year.
and the only egregious one that, and of course, just like you, I wouldn't want to do one night in jail, okay, or one day. But what I don't see this huge problem with the rest of the state.
If you're asking me a question, I'm happy to answer it, but it seems like thus far I've gotten a lot of commentary. So the question is,
So do you see the rest of the state having this huge problem with incarceration victims?
Number one, as been stated repeatedly by all the prosecutors that came up here, they're not even using it.
Right.
Exactly.
But there is the option to have the federal marshals go get that witness.
Let's be clear on a couple of points. And I mean, I'm trying to save a lot of my umbrage for my closing, but I will try to answer your question directly. It is a archaic practice that most DAs have moved past. I understand they still like the option. They probably like the option to have non-unanimous juries too, Bodie. But you know what? Sometimes when something's wrong, you have to correct it. It's not a practice that any modern DA uses. Yes, there are some egregious examples in my parish, and I appreciate that. And certainly I don't want to singularly shine a light on him, because the reality is that the fact that we even have this in statute and it's allowed is offensive in itself. The reality is this, and I know time is short, so Mr. Chairman, if I could I just roll my answer into my closing so that you can get out of here?
You can when we get there, but Senator Colon also has questions. So, Senator White, do you have further questions? Anybody else out there?
I also have some doubt that if they put a witness in, it would be more like a protective witness situation. Don't put them into the general population of the parish prison.
I will tell you that, and this is quite a common practice in this committee in particular, this bill was pre-filed. If there was an effort or a desire to compromise, I'm more than happy to discuss it. As many of you know, they don't do that till bills leave this committee. Because the bill was pre-filed. If someone wants to meet with me and talk to me about other options, I'm happy to do that. That option was on the table, but no DA has contacted me whatsoever. So to answer your question, as Senator Carter said, if there is some other option out there, I know that there was some conversation about using ankle bracelets instead of other things. Happy to discuss that if you want to talk to me about it. But this bill was pre-filed. No one approached me on it. So I'm not saying I'm against it, but it certainly hasn't been brought to my attention yet.
Any further questions, Senator White? All right, and also on taking umbrage with people doing commentary. This is a Senate. We do lots of commentary. We're all very guilty of that.
The commentary is not. The commentary is not what has created my discomfort.
All right,
it was
because
testimony.
we all
I'll address
do
that
it.
at the appropriate time.
So, Senator Colon.
I like commentary. It helps. I give lots of commentary too. So.
All right, Senator Colon.
So, Mr. Chair, I have an amendment.
Would you pass the amendment out, please?
One of the ladies talked about the defendant being able to call the victim as a material witness. So I just wanted to, my amendment basically says that the defendant's attorneys or whoever can't call that same victim as a material witness either.
Okay. This is Amendment 605. And Amendment number 1.
I don't want you to get a cut.
Does with the caption, I think. Yep.
And that doesn't give the defense a leverage over what the DA can't do.
And to be clear, you're not saying they can't subpoena them. You're saying you can't force them to be incarcerated to testify.
All right. So just let's get the witness. Give Senator Morrell a copy of the Amendment 2 as well. But basically, the amendment strikes lines 1 through 7 in the current bill, and Senator Colon's amendment would become the bill.
I was giving that point of clarification, Senator, just to make sure it wasn't unconstitutional. So both sides could still subpoena the witness. The judge could still put the witness in contempt for not showing up. It just simply prevents either side from requiring the witness to be pre-jailed before trial.
Correct. Any objection?
Yeah, I'm still digesting it. Everybody else take a moment to read it and get it. All right. So, Senator Colon, you're just, if I understand your amendment right, you're trying to make it work both ways for the prosecution and the defense. Is that correct?
Correct. But because the DA, the lady that does the
one of those proof of right testimony insinuated that the defense could still require a material witness warrant and still have the person locked
That's
up
correct.
on their own for trial. So it wasn't really doing anything. That was kind of what was insinuated.
All right. So, any questions for Senator Colon on the amendment? Senator Colon moves to adopt her amendment. Any objection to adopting Senator Colon's amendment? Seeing no.
and I have a question.
On your own amendment?
No,
After
not on my amendment.
All right. So
Just-
the amendment's adopted. Senator Colon for a question.
Okay. Helena, you may know the answer to this better.
Come forward,
If you just
please.
come up for a second.
And just as she comes forward, we're going to do Senator Gary Smith's bill after this one. The other item on the agenda relative to bail bondsmen, we're getting kicked out of the room, and the rest has to go to health and welfare. So bail bond bill will be heard next week. All right, go ahead.
So my question was, we're talking about the victim going to jail and that kind of thing. We didn't address that if the victim is working and she loses her job, what happens to her kids and that kind of thing. But you had a lot of data, and one of the things that came to mind was a reason why a victim would not testify would be kind of like that Stockholm syndrome thing, when they've kind of identified, because it's somebody usually that you love, and they, in a lot of instances, they're taking care of you financially and that kind of thing. And so, have you seen any data on some of the victims maybe having a Stockholm syndrome or something similar to that, where they just, they can't do it because like in my instance, I still loved my husband, and he's beating the crap out of me and shooting in the house and all kinds of stuff, and I couldn't find the strength at that time. Now I'm a whole nother lady at this time,
Right.
but I mean, what I'm saying. So
That's actually more the norm, Senator Colon. That feeling of what can I do on my own remember, domestic violence is about control, right?
Yes.
And so this person has controlled every aspect of your life, from your finances to where you go to
the heart
to what you wear, to everything. And so it's all about control. And what do you do when you are so used to that, when you no longer have that, and can you move forward that way?
Yeah.
So all of that is part of it as well.
Yeah.
And so that's why, another reason why it's difficult to entice this testimony as well, only by showing that there is support, that you can be protected, that you will survive this, that you can get through it, and by those services out there that can do that. And that's what you offer. You don't offer jail time for someone going through something like this. You offer those services.
Okay, that's what I just wanted to know. That's it for me, Mr. Chair.
Yes, ma'am. Thank you, Senator Colon. Senator Mills.
Thank you, Mr. Chair. I guess on that same light, from what I'm hearing, and I guess maybe it's a question or an editorial, but it seems like jail would not be the place for these victims. It looks like every community, every judicial district has safe havens. They have places that to me would just be so much more conducive to have somebody waiting for testimony instead of a jail. And I just can't see why this solution can't be resolved pretty easily. And I'm happy you brought this to the discussion.
And I think hopefully after we get a committee.
He's not asking for an answer there. That was commentary.
Okay.
Yeah. So
I understand.
All right.
Hold on. So I don't see any further questions on the board. You're welcome to close.
Thank you. I will be short. Ladies and gentlemen, you heard a lot of testimony here. I'll get the highlights. I had a lot of issues with the way the opposition couched their testimony. I will tell you that if we were talking about anything but sexual assault victims, we're talking about any other situation, and we said, trust the government to know when they should lock you up, it's in your best interest, no one here would be for that. And ultimately, what the situation comes down to is we're telling domestic violence victims and sexual assault victims, trust us, we know what's best from you. You're going to go chill in jail until we get a case. Now, mind you, no one's talking about one real basic fact. What happens when you jail a sexual assault victim against their will? They lose their job, they lose their kids, and you lose the case. No one talks about that. So you've taken a sexual assault victim, you've re-traumatized them, you've put them in a different, more difficult situation, and because the cops bungled the evidence, the DA couldn't get their case together, the case gets lost. Let me be very clear, and Ms. Dorsey can appreciate this. When that prosecutor sat up here and said, this is a pro-defense, pro-aggressor bill, I felt like I need to take my earrings off. Those of you who know me and the bills I bring know that is the most offensive piece of crap someone could say about me. Okay? I'm about as anti-domestic violence and sexual assault as you can possibly be in this building. Ladies and gentlemen, when they played that ridiculously long, offensive, cursing-laden tape and had the audacity to say, the children of the other victim, where's the mom? She's in jail. So thank you for presenting evidence to support what I'm saying. You're right. Those kids are a victim, and their mom, who should be taking care of them, is in jail for a case they may or may not win. Ladies and gentlemen, I am not for aggressors skating on this. I'm not. And certainly I would have appreciated an opportunity to work out a compromise. No compromise was presented. This bill is for victims. It's at the request of victims' rights groups. That's why I filed this bill. That's why it's before you here today, ladies and gentlemen. And certainly, I am always happy. Many of you know, Pete knows, if you want to work with me, I will work with you. But it is not required that I am to anticipate what your objection may be when you don't even tell me what it is. Thank you.
Thank you, Senator Mills. Senator Morrell.
That's a
Morrell.
Wow, you're all over the place right now.
It's a slow day. So, thank you, JP. More coffee for me. There's been a motion by Senator Carter to report the bill favorably as amended. Is there any objection or other motion? All right, Senator White.
There does need to be some work on it.
Yeah.
Some of the things that were stated today are real. Whether you agree, and I understand you're making a passionate close, but there's problems with this bill.
Yeah.
And I understand you have a problem in your parish. I understand that.
But
I don't have a problem in my parish with it. Neither four of them. Okay.
And in your four parishes, they aren't using it.
All right. So thank you, Senator White. I'm going to make the substitute motion because I do think it's important that we continue to talk about it. To report it unfavorably, I don't expect to win, but I want there to be some discussion to know that it's not a unanimous thing coming, or we could hold it. Senator Carter.
Well, I think there's already, and I respect your motion, although I don't support it. I think that there's already been a tacit commitment that there's going to be discussion between now and the floor, should the bill come out favorably, that there'll be an opportunity to talk about some of the alternatives that I suggested, like safe house, ankle bracelets, some other means of compelling witnesses to show up without treating them as a criminal when in fact they're a victim. So it is my hope, and I don't see anyone objecting to that at the table or in the audience, that there'd be an opportunity for some further visitation to see if there may be some ways that we can meet close to the middle and get,
all right,
pun intended, unanimous consent.
All right. Thank you, Senator Carter. So there's been the motion to report favorably as amended. There's been the substitute motion to report unfavorably by the chair. There's an objection by Senator Carter to the substitute motion. Call the roll.
The votes on the substitute motion to report unfavorably, correct?
Yes.
So I'll make
Mr.
sure everyone
Parliamentarian.
Case.
Our committee, our committee understands what the vote is. The vote is I've made the substitute motion, and I've asked her to call the roll. So a yay is unfavorable.
Senator Hengens? Yes. Senator Barrow? No. Senator Carter? No. Senator Cologne? No. Senator Mills? No. Senator White? Yes. Senator Clater?
Yes.
Yes. 3 yeas, 4 nays.
Substitute motion fails. Now we're back on the original motion. Call the roll. So a yes is going to be to report it favorably.
As amended.
Senator Hengens? Yes. Senator Barrow? Yes. Senator Carter? Yes. Senator Cologne? Yes. Senator Mills? Yes. Senator White? No. Senator Clater?
No.
No.
The bill will be reported favorably. The vote was 5-2.
Thank you.
Thank you.